Okay, today we are talking about depositions. Specifically, we're talking about what depositions are not, and what you can expect if you have to file a lawsuit for a personal injury or an accident or an employment discrimination matter, what you can expect in terms of having to give a deposition and what the whole process really looks like. Now, if you've never been involved in a legal claim before, you may have heard the word deposition on a television show, or if you've ever gotten a speeding ticket, you'll see that the police officer typically gives you a supporting deposition. That is not what we're talking about here in the context of a deposition in a civil matter. So let's say you got hurt in an accident, or let's say you were fired from work illegally. You come to our office and we talk about what your legal options are, and ultimately we have to file a lawsuit against the wrongdoer, whether it's the other driver, the property owner, or the employer, okay? Now, in the context of that lawsuit, there are various stages of the case. There's a discovery stage where everybody exchanges paperwork, and within that discovery stage are depositions. Now, depositions happen in just about every case. Depositions are not trial testimony. You are not in a courtroom. Most often, like 99% of the time, there is not a judge present. But depositions are important. As I often tell clients, consider them to be just as important as trial testimony, because everything that you say in a deposition is transcribed by a court reporter. And once you have an opportunity to review the transcript, it becomes your statement. So if you later go into a courtroom and say something that is different from what you said in your deposition, guess what? It will be used against you. So a deposition is an opportunity for the other side of a lawsuit to ask you questions about your claims, about your injuries if it's a personal injury case, about your economic loss in either a personal injury case or an employment discrimination case, and all about lots of things about the claims that you're making. The thing you have to understand when you give a deposition is that depositions are broad. For the most part, when a plaintiff files a lawsuit, they are an open book. And because of that, and because of the way the rules in New York operate, pretty much anything is subject to discovery during the course of a deposition. So lots of times questions are asked that the person giving the deposition thinks are completely off wall, unrelated to the claims in the case, relating to background and education. And they say, why do I have to answer these questions? And the reason is because that's the way the rules work. So a deposition is, again, an opportunity for the other side to ask questions. So who's present at a deposition? Well, if I'm your lawyer, I'm there. And you, as the person giving the deposition, are obviously there. And then the lawyer for the other side, for the other party or parties that you filed a lawsuit against, they're there as well, obviously. So going back to that car example, you're in a car accident, you file a lawsuit against the other driver, that driver has an attorney, that attorney is the one asking you questions at your deposition. Now, if there are multiple parties, then there would be multiple attorneys who all have the opportunity to ask you questions at that deposition. The only other person typically in the room at a deposition would be the court reporter. Now, the court reporter has a little typewriter and will record everything that you say, everything that everyone says throughout the course of the deposition. And as I said, afterwards, they'll produce a transcript, which will then turn into your statement. Everyone who is at the deposition as a lawyer has an opportunity to ask questions. Typically, if you are the plaintiff in a lawsuit, the primary questions will come from the attorney for the defendant or the person that you are alleging caused your injury. The parties to the lawsuit also have a right to be at the deposition. So if you filed a lawsuit against another driver or a property owner or a company, they are entitled to have someone present to see what you have to say. Not always the case, but it is something that they're entitled to do. How long does a deposition last? Depositions can be quick, and when I say quick, I mean an hour, or they can be long. Depositions sometimes can take most of a day. They can occasionally go beyond that. It all depends upon the complexity of the case, the complexity of your injuries and your damages, and frankly, the personality of the people involved. Sometimes witnesses like to talk, sometimes witnesses are combative, and sometimes lawyers are the same. Sometimes lawyers like to ask very long questions. They like to ask a lot of questions. Sometimes lawyers are much more direct and to the point. The short answer is a deposition can be short or long. Typically, it will be done within the course of one day. Sometimes it goes beyond that. the takeaway from all of this is that if you are involved in a lawsuit, you have to go into it with the understanding that you may have to give a deposition. It's not something to lose sleep over, but it's something that is important. And it's important that if you're working with an attorney, you talk to them about what you can expect during the course of that deposition. And if you're extremely uncomfortable giving a deposition, that's something to talk to your attorney about before you file a lawsuit. There are several factors that go into the consideration of whether to file a lawsuit or try to resolve a case before filing a lawsuit. And one of those factors is the decision as to whether or not you really don't want to give a deposition. You really don't want to testify if it has to go to trial. Some people are really opposed to that kind of thing. And in those cases, it makes sense to try to see if you can resolve the case without filing a lawsuit. That's basically an overview of the deposition. If you've got questions, feel free to reach out to us.